Hi students, today we will cover Unit 2, which is consideration. Unit 2 has been divided into 4 subtopics: definitions, legal rules regarding consideration, sued by a third party to a contract, validity without consideration. Let us discuss about definitions. So definition of consideration, there are two types. One is from the Act itself, another is from case law. From the Act, which is Section 2, Clause D of Indian Contract Act 1872, describes consideration as when at the desire of the promisor. When at the desire of the promisor. Let us take an example. So A wants to sell his car to B. A wants to sell his car to B. Now A wants to sell his car to B at rupees 5 lakhs. So who wants 5 lakhs? A wants 5 lakhs. Whose desire to obtain 5 lakhs? A's desire. So there are two persons in the contract: offerer, offeree, promisor, promisee, or you can also say promisee or offeree as acceptor. So at the desire of offerer, at the desire of promisor, what should happen? Who should give? Either promisee or any other person. Either promisee or any other person. So in the given example, either B can pay money or some other party, stranger, some C, D, E, whoever it may be, who can pay. It can be B or it can be any other person. B or any other person. But whose desire? It should be A's desire. It cannot be a stranger desire. It cannot be a third party desire. It cannot be any other person. It should be desire of promisor. But the one who is paying can be promisee or any other person. The money can come from B or any other person. But the money should be at the desire of promisor, at the desire of A. So what could have happened? Has done or abstained from doing. Does or abstains from doing. Promises to do or abstain from doing something. So 3 times: past tense, present tense, future tense. Has done or abstained from doing. So past consideration. Let us continue the same example. A has already given advance. A has already given advance. So at the desire of the promisor, at the desire of A, B has already paid the money. So which is a past, which is executed, which is past. Does or abstains? Present. He want to pay right now. He want to pay right now. All your trade on real-time basis, on instantaneous basis, are present tense. Promises to do or abstain from doing. You give me the car today, you collect the money after a week, after a month. All your credit sales comes under this third section. So first is past, second is present, third is future. Has done or abstain from doing. At times you also give advances to many parties. Let us say you want to order a cake. So you give some advance. You pay money in advance. You pay consideration in advance for the act which is going to do it in future. So there is a consideration which can be past. There is a consideration which can be present. There is a consideration which can be futuristic. So who should pay? Promisee or any other person. At whose desire? At promiser's desire. When at the desire of the promiser, promisee or any other person has done or abstained from doing, does or abstains from doing, promises to do or abstain from doing something. So the example which you have taken is for the sake of positive activity. So you need to pay money. You need to paid money. You have paid money, or you are paying money, or you will be paying money. So that is positive activity. What is abstained from doing? Abstains from doing. Promises to abstain from doing something. So abstain from doing. In the past, someone has, based on your instructions, someone has not established his business in that premises. In the past, someone has listened to you, someone has followed your instructions not to establish a shop near his premises. That is past consideration. Abstains from doing. In the present, he is doing. Let us say for the next 1 year, he is not going to do it. Promises to do. He is telling in the future he will not do it. So negative statement, negative past, negative present, and negative future. Abstains from doing, and promises to abstain from doing something. Who? Promisee or any other person. At whose desire? At the desire of promiser. So there are three positives: past, present, future positives, past, present, future negatives as well. Doing, not to doing. Who should do, who should not to do? Promisee or any other person. At whose desire? At the desire of promiser. So such act you call it as, such abstinence or such promise you call it as consideration for the promise. Easy to remember. So you start with at the desire of the promiser, promisor, any other person does something, done something, promises to do something, abstained from doing something, abstains from doing, promises to abstain from doing something. All these acts put together, or abstinence or promises put together, you call it as consideration for the promise. So here, as we have discussed already, there are three time zones: past tense, present tense, and future tense. And there is positive activities and there are also negative activities. This is the definition of consideration as per the Act, as per Section 2D of Indian Contract Act. Next, we'll discuss definition as per case law. So there is a case law called Misa versus Curie. In this case law, the definition goes this way: a valuable consideration in the sense of law. Valuable consideration in the sense of law may consist two things: either in some right, interest, profit, or benefit accruing to one party. What he is telling, valuable consideration in the sense of law may consist two things: either in some right, interest, profit, or benefit accruing to one party who is promisor, or forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other party, that is promisee. So what they are going to tell? They are going to tell, while paying consideration, one is gaining something, one is losing something. So let us see an example. Either in some right, let us say publisher got right to publish author's book. Publisher got right to publish author's book. So A is an author, P is a publisher. So P got right to publish the book. So P got some right to publish the book. That is, promiser got right to publish. He got some right. At the same time, whose hard work is that? That is the hard work of Mr. A. Mr. A loses some value, loses his value, or he want to share his hard end script. He want to share his book with publisher. So that we call it as detriment. Detriment is loss of some value, loss of some value. So publisher is getting some right, author is losing his book. Let us take the same consideration, same scenario. In the same scenario, publisher is losing his money. Publisher is losing his money. His hard-earned money is losing. Whereas here, author is getting some benefit. Author is getting some money benefit, right? So if you remember the definition of agreement, promise, every set of promises forming consideration to each other. So considerations are both ways. Consideration are both ways. So publisher is getting the right, at the same time author is losing his hard-earned content. Publisher is losing his money, at the same time author is getting benefited. So one-way consideration has two aspects, positive as well as negative. So similarly, you have interest, you have profit, you have benefit. Let us say you lend money to someone. You lend money to someone. In this case, you will get interest on that money. So that is, interest is positive. The other person will lose some money, some detriment, loss of value. Let us say benefit or forbearance. So in the previous example, we've discussed that based on instructions of Mr. A, B doesn't want to establish his shop in nearby premises. So what he's doing, he's forbearance. He's forgoing the opportunity of opening a shop in his own hometown. He is losing that opportunity. So what the other person is getting, he is benefited because the other person is not opening the shop. So every consideration has two aspects. A valuable consideration has two aspects. One party will get some right, interest, profit, or benefit. Other party will lose something of value, loss, or responsibility undertaken by the other party. Hope it is clear. This is the definition as per case law. So we have discussed two definitions. Definition of consideration as per Act, definition of consideration as per case law, which is Misa versus Curie. This is the first aspect. Next, we'll move to legal rules regarding consideration. Legal rules regarding consideration has 8 rules. Let us talk one after another. Consideration must not be unlawful, immoral, or opposed to public policy. So very straightforward legal rule. It cannot be unlawful. It cannot be immoral, or it cannot be opposed to public policy. So can you trade in drugs? Can you give drugs as consideration? Can you pay Bitcoin as consideration? In India, Bitcoin is illegal in India, whereas Bitcoin is legal in some other countries. Can you give drugs? It is unlawful. So consideration has to be lawful, consideration has to be moral, and it has to be as per public policy. It should not oppose the public policy. Very straightforward legal rule. You can easily remember. Consideration must not be unlawful, immoral, or opposite to public policy. Thereafter, consideration must move at the desire of the promisor. This we are getting from the definition itself. Consideration must move at the desire of the promisor, right? It should not desire, it should not be moving desire of third party or a stranger. That was discussed in this case law, Durga versus Baldev, where that consideration should move from the desire of the promisor, not from the desire of a stranger or third party. Again, this coming from the definition itself. Consideration may move from promisee or any other person. Coming from the definition itself, consideration may move from promisee or any other person. The one who is paying the consideration, the one who is giving the consideration can be either promisee or third party or a stranger. So a stranger to a consideration is acceptable, very much acceptable. A stranger to a consideration is acceptable. Coming second and third point are coming from the definition itself. Fourth point, consideration may be past, present, or future. Again, it's coming from the definition itself. Consideration can be you would have paid advance in the past, you are paying currently, or you may pay in future, credit sales, right? So there are 3 legal rules coming from the definition itself. So once you can remember the definition, you already got 3 legal rules along with the definition as per Act. So next, we have performance of what one is legally bound to perform. Performance of what one is legally bound to perform. So let us say collector wants to do his duties. A police officer should do his duties. Lawyer should do his duties. Doctor should have done his duties. So what they are supposed to do, what they are legally supposed to do, that cannot be considered as consideration, or that performance cannot be considered as consideration, right? So performance of what one is legally bound to perform is not considered as consideration, will not be considered as consideration. Is that clear? You already paid money, let us say for coaching. So now you're getting the coaching. The teacher should able to provide you classes, provide you material, provide you enough guidance, etc. But in order to do that, he is again asking more money. So what he is legal to bound to perform. If he asks more money, that will not be taken as consideration. So what he is legally bound to perform, we cannot consider it as consideration. Next, we have consideration need not be adequate. So here we need to discuss consideration. The Latin word for consideration is quid pro quo. What is that? Quid pro quo. Quid pro quo means something in return. Something in return. It doesn't need not to be adequate. Let us say a land worth of 10 lakhs. Person is selling at 1 lakh. So maybe, right? So he can sell at 1 lakh, but you can say the property value is 10 lakhs. It is his wish, it is his will, right? So here consideration should be there, but consideration should be adequate, need not be, not necessarily be. So a property worth of 10 lakhs, a gold chain worth of 5 lakhs, a car worth of 4 lakhs, someone wants to sell at 1 lakh 50,000, right? It is acceptable. Something in return, quid pro quo. There should be a consideration, but consideration should be adequate, not necessarily be. So the sixth rule is consideration need not be adequate. So 10 lakh worth of land, someone is selling at 1 lakh. Fine. It is not illegal. Consideration need not be adequate. Next, consideration must be real but not illusionary. So consideration should be real but not illusionary. Let us say he want to, he will find a treasure for you. He'll find a treasure for you. That will be taken as consideration. So illusionary, impossible tasks cannot be taken as consideration. Consideration must be real. Executed and executory. So let us take a transaction, the same example of A and B selling a car for 5 lakhs. A has delivered the car to B. B will pay the money in future. B will pay the money in future. So A, A has already delivered the car to B. So A has done his consideration. But B's consideration of paying money is in future. So A's performance is executed, B's performance is executory. What is the difference between executed and executory? Executed is past tense, executory is future tense. So executed and executory consideration. The difference is a consideration can be executed, a consideration can be executory. So person has paid money in advance, but the car will be delivered after 15 days. In this case, the money received is consideration. The car which is executed, the car which is getting delivered after 15 days is executory consideration. So 8 legal rules we have. Let us repeat once again. So we need to also note must. The first point is must, mandatory. Consideration must not be unlawful, immoral, or opposed to public policy. We can also read it as consideration must be lawful, consideration must be moral, consideration must be aligned with the public policy, not opposed to public policy. So must, it is mandatory. There is no exemption. Second, consideration must move at the desire of the promiser, not from the stranger, not from the third party. It should must move from the desire of the promiser. Here also must, which is mandatory. Third, consideration may move from promisee or any person. Here we are using may. It can move from promisee or any other person, stranger or third party. Yes. Here there is a flexibility. Consideration, again may, flexibility. Consideration can be past, consideration can be present, consideration can be future. Here also there is a flexibility. So you can pay money today, you can take the delivery after 10 days. You can pay money now and you can take the delivery now, which is present. You can take the delivery today, you can pay the money after 10 days, which is future. That is, consideration can be past, consideration can be present, consideration can be future. This is also flexibility. Performance of what one is legally bound to perform does not consider as consideration. So once a collector has to be doing his duties, for performing his own duties, he cannot ask money. He cannot ask money. So performance what one is legally bound to perform shall not be treated as consideration. Consideration need not be adequate. So what we have discussed, a 10 lakh worth of gold chain, you are paying 1 lakh. So if that consideration, if that party has a free consent, then it is fine. Consideration need not be adequate. So consideration must be real but not be illusionary. And finally, you have 8th point, executed and executory. One is past, one is future. So 7th point, you can also underline must. Consideration must be real but not illusionary. So with this, we are done with 2 subtopics of consideration. Number 1, which is definitions. We have covered definitions as per Act, definition as per case law. Then we have also covered legal rules regarding consideration. In the next video, we will cover other 2 subtopics, which is sued by a third party. 4th, which is validity of agreement without consideration. Thank you.